not 154 of the Evidence Act. Not I'll confine myself to the points, not which
Ashte,
just
that's all.
4 lines. That's all. I'll not trouble you a lot again. Not examination in chief of not this PW one not was conducted on not 17/12/2025.
17/12?
12/2025.
Yes.
Not cross examination by the counsel for A1 was done on 17/12 and 18/12/2025. The counsel for A2 sought time. And no, it was adjourned. Cross examination of PW1 at the instance of A2 was adjourned to 29/12/2025. There was gap of about 11 or 12 days. No, can I draw your lordship's kind attention to page 414? The first point, not why we sought permission.
Page 414.
414. But I'll confine myself to the point of law that if I am able to bring to your lordship kind notice that what witness has stated is apparently false, then 154 comes into picture.
414.
414. Not this is the call record detail CDR. Not serial number 1 and 2 may kindly be seen.
Pepsi Nelmangla.
Allah. Idralli. Not the serial page
414.
414 ಅಲ್ಲಿ. Page number
414 last page.
ಹೌದು last page.
Last page.
ಮೇಲ್ಗಡೆ first 2 ಮೇಲ.
ಅದೇ Pepsi Nelmangla.
ಅದು next ಅದು first ಆಯ್ತು. Second and third, I'm sorry. Second and third.
Vinayak Nagar.
Vinayak Nagar. ಇದರಲ್ಲಿ your lordship will find in the second column these 2 telephones.
Call out.
ಇದೆಯಲ್ಲ ಅದು they are standing in the name of the father of the deceased Kashinathaya, whose name appears as a sub name B Kashinath Shivanagowda.
ಆಯ್ತು. Who has called?
This was used by the PW1 mother where she admits. But the call your lordship will find there is a call duration of 27 seconds and 47 seconds. On the date of incident, your lordship will find 8/6/2024. Serial number 2.
Called to whom, sir? From whose phone to whose phone?
Mother's phone to the phone of the deceased.
So what?
This is 1 nimsha. The your lordship will also find tower location. This is not close to the scene of crime. What mother says is this is a documentary evidence available. There is a call between mother and son and during the time of incident, not in the afternoon. What mother says not in the cross examination is at page 336. What she says, I had not received any call from my son during this relevant period. In effect, of course there are documentary evidence to show that in fact the deceased was in the scene of crime. Mother says I have not received any was not in the scene of crime.
I think you're drawing too much inference on this.
She says I have not received any call, but the records indicate that she in fact had received call and the tower location.
What becomes of that evidence? Now you want to turn her hostile and cross-examine on these things, or tacitly cross-examine without declaring her hostile. That is your submission.
She says this phone belongs.
Only these 2 instances you want?
There's one more your lordship will find. Not page 367, not the inquest.
Inquest,
367. Not there, not last column number 4, last 4 lines of this page. Ink page 367. Last page. ಮೃತನು ಜೀವಂತವಾಗಿದ್ದಾಗ ದಿನಾಂಕ 8/6/24 ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 2:30 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಮೃತನ ತಾಯಿ ಶ್ರೀಮತಿ ರತ್ನಪ್ರಭಾರ್ ಅವರು ತನ್ನ ಮಗನಾದ ರೇಣುಕಾಸ್ವಾಮಿಗೆ ಫೋನ್ ಕರೆ ಮಾಡಿ ಮಾತನಾಡಿದ್ದು, ಮೃತನು ತನ್ನ ಹಳೆಯ 4 ಜನ ಸ್ನೇಹಿತರೊಂದಿಗೆ ಹೊರಗಡೆ ಹೋಗುತ್ತಿದ್ದು on certain important aspects simply may not says I have not given such statement, I have not received call, which goes contrary to the documentary evidence available on record. Then my lord, not page 376 your lordship will find. Page 376, not para 3. Not para 3, 4th line. Note. ನಂತರ ಆತ 4th ಲೈನ್
ನಂತರ ಆತ ಮಧ್ಯಾಹ್ನದ ಸಮಯದಲ್ಲಿ
ನನ್ನ ಹೆಂಡತಿಗೆ ಫೋನ್ ಕರೆ ಮಾಡಿ
ಯಾರಿಗೆ? ಹೂ ಇಸ್ ಸ್ಪೀಕಿಂಗ್?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿ ಫಾದರ್.
ದಟ್ಸ್ ದಿ
ಮಧ್ಯಾಹ್ನ ಊಟಕ್ಕೆ ಮನೆಗೆ ಬರೋದಿಲ್ಲ, ನಾನು ನನ್ನ ಹಳೆಯ ಸ್ನೇಹಿತರ ಜೊತೆಯಲ್ಲಿ ಕಾರಿನ ಹೊರಗಡೆ ಊಟಕ್ಕೆ ಹೋಗೋದಾಗಿ ತಿಳಿಸಿದನು. ಮದರ್ ಸೇಸ್ ನೋ, ಮೈ ಹಸ್ಬೆಂಡ್ ಹ್ಯಾಸ್ ನೆವರ್ ಸ್ಟೇಟೆಡ್. Of course, my lord, it is a different issue. It should have been confronted to husband. No, my lord, the fact remains, the call record details indicate the location of the deceased, not at the not scene of offense, where my lord, location will be generated only
ಯಾಕೆ
when there is
ಬೇರೆ
a call.
ಎವಿಡೆನ್ಸ್ ಇಲ್ವಾ?
There is evidence definitely there. Not very evidence definitely. This may not one. Then kindly have a look at the second one. Not page 337, my lord. 337. What mother says. Not para 2.
337.
37. In page 337. Internal page 40 of not evidence of PW1. ಶವ ಮಹಾಜರ್ ಮಾಡುವ ಕಾಲಕ್ಕೆ ನಾವುಗಳು ಮತ್ತು ಸಂಬಂಧಿಕರು ಹಾಗೂ ವೈದ್ಯರು ಇದ್ದರು. ಅದೇ ರೀತಿಯಾಗಿ ಪೊಲೀಸರು ಇದ್ದರು. ಶವದ ಯಾವ ಭಾಗಗಳಿಗೆ ಯಾವ ಆಯುಧಗಳಿಂದ ಗಾಯಗಳಾಗಿವೆ ಎಂದು ಪೊಲೀಸರು ತೋರಿಸಿದರು. ಸಾಕ್ಷಿದಾರರು ಮುಂದುವರಿದು ನಾವು ನೋಡಿರುತ್ತೇವೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ನಾವು ನೋಡಿದಂತೆ ಪೊಲೀಸರು ತೋರಿಸಿದಂತೆ ಯಾವ ಯಾವ ಆಯುಧದಿಂದ ಆಗಿರುತ್ತದೆ ಅಂತ ಪೊಲೀಸರು
ಅಲ್ಲ, ಇದು ಯಾರು? ಮದರ್
ಮದರ್. ಡಾಕ್ಟರ್ ಬಳಿ ಆಯುಧಗಳು ಇರುವುದನ್ನು ನಾನು ನೋಡಿರ, ಪೊಲೀಸರ ಬಳಿ ಇರುವುದನ್ನು ನಾನು ನೋಡಿರುತ್ತೇನೆ. ನಾಟ್ ದಿಸ್ ಶವ ಮಹಾಜರ್ is on 11/6/24. Where may not spot murder and recovery of the weapons not happens only on 12/6. This again may not her statement
contradictory.
Not completely contrary not to the documents. Then may not your lordship will find. Then on the next page, page 338 may not. Para 2. ಪೊಲೀಸರಿಗೆ ರೇಣುಕಾಸ್ವಾಮಿ ಅನ್ನೋದು ಆತನ ಐಡಿ ಕಾರ್ಡಿನಿಂದ ಗೊತ್ತಾಯಿತು. But in the entire case of the prosecution, ID card is not recovered at all. She says police came to know that this is my son only through ID card, which is not again apparently. Then not the last one. The next page, not page 339 and 340. ಪೊಲೀಸರ ಮುಂದೆ 3 ಬಾರಿ ಹೇಳಿಕೆ ಕೊಡುವಾಗ 339. ಪೊಲೀಸರ ಮುಂದೆ 3 ಬಾರಿ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ನನ್ನ ಮಗ ಪ್ರತಿ ಶನಿವಾರದಂದು so and so. All that she has given statement is only once, 161. Not when I sought permission under section 154 and sought permission of the Hon'ble Court. The main contention of the counsel for A2 was, no, she has stated 3 statements. Where are the other 2? They have suppressed. But in fact, as per the records, it is only not one statement that she has given.
161 statement ondena?
Onde irodu.
These are the contradictions.
These are the major contradictions.
No, you want to declare her hostile or just
I
put
do not
questions?
want to declare her hostile. I want to seek explanation from her. Where are the? Did you really give? What she says is, I met police commissioner. Then I went to hospital for inquest. Then I went to police station for giving statement. She to the questions asked, did you state anything before the commissioner? She says yes. Then did you state anything during inquest? She says yes, which is not correct. I want to ask whether it was only oral or not written.
What's the judgment?
Please, may I just.
Instances idena?
Instances idu. Court copy. May I just. Or copy.
Tamil Maran.
Our latest
paragraphs hakidira?
Paragraphs hakidin.
Right.
All that, all the judgment says, if I am able to show to the Hon'ble Court that the witness is lying. ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತಿದ್ರೆ ಅದರ ಬಗ್ಗೆ 154 ಅಲ್ಲಿ without
lying or only trying? Trying to lie. Yes.
And things go contrary to call record details.
We'll
And
see,
mother
yes.
not supporting, but is very difficult. Please.
Sir.
In this case, my lord, the witness, my lord, is the mother. My lord, she has deposed.
Prosecution witness.
Yeah, prosecution witness. She has deposed entire evidence in support of the prosecution. She has not turned hostile at the stage of examination chief. My lord, the term was next is for adverse party to cross-examine. My lord, adverse party, that is accused counsel, has put certain question. He has given admission that has been recorded. Even those admissions are not required clarification at the stage of re-examination. This is very important, Your Lordship. If at all, if any ambiguity is there, the stage is there at the re-examination stage. Re-examination was nil.
Re-examination.
I'm sorry. Just to clarify.
Re-examination
I
is
sought
nil.
re-examination. I said, permit me to question either as re-examination or under 154(1). That was my prayer. which is
Re-examination is rejected?
recorded. That both are rejected. Not your lordship will find on my prayer.
ಅಲ್ಲ ಪ್ರೇಯರ್ ಇರ್ಲಿ, ಆರ್ಡರ್ ಏನಾಗಿದೆ?
Order ಅಲ್ಲಿ 154 ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes, Pasha sir.
Please, your lordship. My lord, re-examination stage also, as per the trial court, my lord, that it does not come any question to be put under re-examination because there is no ambiguity. Lord, merely because some inconsistent evidence is deposed. There is no inconsistency, my lord, that she has not given evidence contrary to examination chief. This is very important. She has not given evidence inconsistent to examination chief. But she has admitted certain questions which were put in the cross-examination, which were required for the defense. Well, the purpose of cross-examination is to test the veracity of the witness.
Correct.
Well, the admissions were elicited. Those admissions, my lord, may speak some additional fact, which is to even to the extent of.
But why was re-examination could have been permitted instead of 154?
Well, re-examination has a limited scope. If it comes, my lord, that is different.
That's what.
Well, treating hostile, my lord, directly they sought for treating hostile.
Treating hostile may not be, but re-examination if it is.
Examination, my lord.
Now, do you have any objection if re-examination is permitted?
That is to be examined by the trial court.
Correct. We will direct the trial court not to treat hostile, but
Yes.
re-examination. Yes, Rangnath.
But if it comes, my lord,
There is absolutely no ambiguity, my lord.
Alla,
Scope of
re-examination see,
only arises ambiguity.
examination in chief, cross-examination, re-examination is all the right of the parties.
Please.
All right. It is not that it is the discretion of the court to permit or not. ಈ 154 other, yes. Whether there is ambiguity or not, there is ಬಿಡಬೇಕಾ ಬೇಡವಾ is bad. ಒಂದು re-examination ಆದ್ರೆ ಏನ್ ತಪ್ಪು?
Please, my lord. If at all, my lord, if they are seeking for re-examination, they must first make out the ambiguity, my lord.
That the
Convince
court will consider.
yes.
Lord, it is not their case that there is ambiguity. It is their case that she has stated adverse to the case of the prosecution. That being the case, my lord,
Then
the
we'll
scope of
consider.
re-examination would not arise, my lord.
All right, we'll see.
There was, at the stage of re-examination, they sought for treating the witness hostile.
No, I did.
Well, here, Lakshmi, kindly see the deposition here.
No,
Yes,
your
350.
application is the stage of re-examination, you asked the,
Yes,
ಇದೆಲ್ಲ ಇಲ್ಲ, no.
yes.
ನಾನು
But, here, the deposition, my lord, at the end, page 351, my lord. On conclusion of her evidence, ಮರು ವಿಚಾರಣೆ, ವಿಶೇಷ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರು ಈ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 17/1/26 ಮಾಡಿದ ಆದೇಶವನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿರುತ್ತಾರೆ. This order, my lord, 17/1/26 is, my lord, which is impugned here in respect of requesting the Hon'ble trial court
Treating
treat the
hostile.
witness hostile. My lord, this is recorded. Kindly see, my lord, at every stage, my lord, when re-examination stage has come, no question was put, so that requires a clarification. My lord, in order to put, my lord, section 138 is very clear that in re-examination, leading question
correct,
cannot
leading
be put.
questions cannot be put. It's only
But
clarificatory.
If any ambiguity, my lord.
See, when the examination in chief and cross-examination concludes, re-examination is not done to go over and above the examination. It's
Yes.
only for clarification of the
If
answers elicited in cross-exam.
That is to be decided by the trial court if there is
Ambiguity.
a scope for re-examination. Like here, that stage was not even taken or directly, my lord, they sought for treating the witness hostile. My lord, re-examination is for that purpose. My lord, if any ambiguity is there,
No, correct, that's there.
ambiguity explanation is
that's-
required, my lord, it
that's
should fall within the
rudimentary.
definition without putting any leading question. My lord, to that extent, my lord, it can be clarified. But my lord,
Alla,
this
you can,
witness,
if
this
you want to re-examine, you, within the contours of law, you can
Yes.
re-examine.
Re-examine.
Contours of law is not that you'll put leading questions to the witness, your witness. Leading questions to your witness, which would be in the nature of cross-examination.
That's why
That can't be.
I have brought to your
Then
lordship.
you restrict your prayer, or your claim to 154, we will answer whether the application is rightly rejected or wrong.
But Your Lordship may kindly consider our prayer under 154 subsection
Then
1.
we'll answer.
Because I brought Your Lordship kind notice how it
See,
is.
I cannot by law or by this order say in the peculiar facts of the case that I amplify the scope of re-examine. That can't be done.
That's exactly.
So, yes.
There are case laws to the effect that, my lord, permitting to put leading question for the party who has called, my lord, is amounts to violation of Article 21 of the Constitution.
No doubt at all.
My
I have
lord,
no doubt about that.
My lord, that they cannot put it.
Pasha sir,
Yes.
that I have no doubt at all.
Yes.
Leading questions by way of re-examination is impermissible in law.
Not only that.
And even to the witness that is called.
Witness who has called by the party, they cannot put any leading question. Even in examination chief, they put, my lord, is amounts to violation of Article 21 of the Constitution. Because that is an irregular method of or illegal method of bringing
eliciting
the
evidence.
on record.
Eliciting evidence.
Eliciting evidence. Well, that is not permissible.
154 will
154.
answer.
No, in fact, there is a purpose of 154. not-
Judgment. Could
Please.
We'll place on record
Kodi,
my lord,
kodi.
certain decision.
There's one authority.
All these
Because the
judgments-
legal issue will answer it.
All these judgments would only say if the prosecution is able to show that the witness has on certain aspects has lied to the court, then not it is permissible.
We'll see.
But the
Whether
lordship
it was
kindly
lies
produce
or whether it was amplification of the statement that is already made.
But merely because, my lord, the witness in an unguarded moment, my lord, speaks something adverse to the prosecution or does not suit the version of the prosecution. My lord, the admissions, my lord, acquired in the cross-examination cannot be ambushed, my lord, by way of.
I think, this is technical evidence versus not oral version. Technical evidence says something,
That's my kindly
oral
produce,
version
my lord,
speaks something
paragraph
else.
16 of Ravindra Kumar De's case, my lord.
No, does not 2025 SEC online SC
Covers
958
everything.
cover the issue?
That covers everything.
That is Tamil Maran.
Tamil Maran.
My lord,
Tamil Maran does not cover the issue.
Factually different. It's factually
Evidentiary
different.
value of a hostile witness.
That is witness
is
was already
different.
treated hostile, evidentiary value of that.
What evidentiary value? Many of the decisions, my lord, they speak that even if the witness has turned hostile, his evidence will not efface. Ultimately, it is for the court to believe it or not. That is the principle of law. But here, my lord, the procedure, whether the party who has called the witness in his support, can he be permitted to put a leading question?
No, correct.
Though-
That will
Though
answer.
the witness has completely supported. There
No,
is
it's completely
obligation.
supported. It looks like the.
That's what the
Hostility is
Tamil
not-
Maran, Tamil
No,
Maran
no,
case alli-
Hostility-
it looks like that the answers are not what you want.
No, not necessarily.
That does not mean that it.
ಅಲ್ಲ ಯಾವ ತರ ಅಂತಂದ್ರೆ now not all of us are here in before the court and not our presence is recorded in the VC. Tomorrow somebody coming and saying no they were not there. VC will speak for everything.
ಅದೇ
But in the same way,
VC ಇದ್ರೆ ತೊಂದರೆ ಇಲ್ಲ ಇಲ್ಲಿ VC
it is
ಇಲ್ವಲ್ಲ.
CDR. Again, not technical evidence.
But this approach, my lord, will dilute any effective cross-examination.
But I can understand between oral and not 161. This is document, not technical evidence versus not oral.
The recent decision, my lord, of Supreme Court also.
But I've also furnished,
Shiv Kumar and another.
No, at every step when cross-examination, see, examination and cross-examination are stubborn facts. Very difficult to demolish them. By this method, if it is permitted, then will it be?
this would be an
All
ambush.
this judgment says if a statement in the cross-examination goes contrary to the documents available on record, then 154 can be
We
invoked.
will see. Yes.
But if paragraph 16 may kindly be perused. At,
ಯಾವ್ದು ಇದ್ರದ?
at
ಶಿವಕುಮಾರ್.
In this
Kumar.
pair, in this page,
Rabindra
my lord.
ಯಾವ
paragraph-
judgment?
Yes, this is the same Shiv
Same
Kumar.
Shiv Kumar.
Paragraph, my lord, I have highlighted you, lordship.
12.
Yes, my lord, that merely because, my lord, para 10, my lord, para 10, my lord, previous judgment on 1977 Supreme Court is exacted.
Merely because a witness,
Merely because a
unguarded moment
witness in an
speaks.
unguarded moment speaks the truth, which may not suit the prosecution, or which may be favorable to the accused. The discretion to allow the party concerned to cross-examine its own witness cannot be allowed. Well, this is the test, my lord, which is, well, many times, my lord, defense able to elicit very damaging admissions. Well, that doesn't mean that it affects the prosecution, therefore they are entitled for custody. Purpose of cross-examination is to see that prosecution case is demolished.
No, correct, of course.
An adverse party, my lord, that they try to elicit certain answers which affects the prosecution.
Well,
And this witness, she is the mother. She has not shown any hostility. She is not some stranger and all that.
correct. If it is
And
on,
she cannot
no,
be.
Prasanna Kumar sir.
Yes.
it is the mother speaking who has lost the son.
Yes,
Then it's not that stranger speaking and contradictory statements being made.
and Supreme Court may have repeatedly said that.
Huh?
That 12 days or 1 year will not make
That,
no
that
difference.
hardly makes any difference. The issue is whether it should be 154 1C permits you. ಯಾವುದು?
Internal page 6 of Shivakumar. Yeah, paragraph number 11 of the legal judgment is extracted. Statement about 10 lines from the top. It seems to us that before a court exercises discretion in declaring witness hostile, there must be some material to show that the witness has gone back on his earlier statement, or
Where is?
he is not speaking the truth, or has exhibited an element of it. He is not speaking the truth, but which could be seen from the documents on that. But weapons not recovered on 12th. He says on 11th I saw everything.
That's why, my Lord, Supreme Court says, in some time unguarded moment, if she speaks the truth, that is not the ground for treating the witness hostile. It may be fact.
We'll answer
Witness has
it.
admitted.
This requires an answer. We'll do it.
Authority.
ಇಲ್ಲಿ ನಮ್ ಕೋರ್ಟ್ ಯಾವ್ದಿಲ್ವಾ?
One decision, my Lord, the whole decision of this court, my Lord, 19 AR 67 Mysore, identical case, my Lord, that.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my Lord, that.
Trial court.
After that, no other judgment?
ಇಲ್ಲ ಯಾವುದು ಬಂದಿಲ್ಲ.
My Lord, this court, my Lord, 77 Supreme Court, my Lord, exactly.
ಆಯ್ತು ಅಲ್ಲ ಈ ಕೋರ್ಟ್ ಇದೆಯಾ ಯಾವ್ದಾರು ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ.
We'll write a judgment.
No, we are troubling your lordship not to write judgment on several aspects.
What to do? We'll do it.
Answering.
Let us steer clear things.
Please.
Lord, in
Yes, Rangnath.
please, my Lord, Ravindra Kumar's case, my Lord. Paragraph 17. My lords may kindly peruse. If I may read so, my Lord. It may be rather difficult to lay down a rule of universal application as to when and in what circumstances the court will be entitled to exercise its discretion under section 154 of the Evidence Act. And the matter will largely depend on the facts and circumstances of each case, on the satisfaction of the court, on the basis of those circumstances. Broadly, however, this much is clear that the contingency of cross-examining the witness by the party calling him is an extraordinary phenomenon, and permission should be given only in special cases. It seems to us that before a court exercises discretion in declaring a witness hostile, there must be some material to show that the witness has gone back and on his earlier statement, or is not speaking the truth, or has exhibited an element of hostility, or has changed sides and transferred his loyalty to the adversary. Furthermore, it is not merely on the basis of a small or insignificant omission that the witness may have made before the earlier authorities that the party calling the witness can ask the court to exercise its discretion. The court, before permitting the party calling the witness to cross-examine him, must scan and weigh circumstances properly and should not exercise its discretion in a casual or routine manner. Lord, in totality, my Lord, if the deposition of the mother is looked into, Lord, why would she, my Lord, be an adverse party to the party calling her? She has lost her son after all, my Lord.
That's what I said.
Please. So it has to be considered holistically, my Lord, not bits and pieces here and there.
Right. Not reserved.
Grateful.
Yes. Because this needs an answer. Just like that, we can't.
Even in Vinay Kulkarni's matter, which your lordship was to please consider.
The answer
Why it cannot
coming
done
up the-
hostile?
No, that's on a different footing.
Of course.
Not this.
Of course.
Not this at all.
Like ಹೆಂಗೆ ಅಂತಂದ್ರೆ ಚೀಫ್ ಎಲ್ಲ
ಅಲ್ಲಿ
that's what
approval
it is said.
ಆಗಿದೆ.
That's
Approval
what it is said. ಚೀಫ್ ಅಲ್ಲೆಲ್ಲ ನಮ್ಮ ಪರ ಹೇಳೋದು. ಕ್ರಾಸ್ ಅಲ್ಲಿ on a certain pattern of questions, she is asked to say,
So
ಹೌದಾ?
that is why, as that judgment ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ, ರಂಗನಾಥ್ ಹೇಳಿದ್ದು. Universal application.
Universal application ಇಲ್ಲ. There are 3-4 considerations. Every consideration is there is a distinction. R ಅಂತ ಇದೆ.
Facts obtaining in each of the cases.
So R ಅಂತಿದೆ.
Or particularly, my Lord, the trial court is better to decide whether the.
Correct.
adverse
I
party-
can't sit here and decide, but it has decided now.
Decided. Therefore, it needs to be answered by.
We'll answer. Legal issue will
But
answer.
in the academic interest, it may kindly.
Correct. No, ಅದಕ್ಕೆ ಕೇಳಿದ್ ಯಾವ judgment ಇದೆಯಾ?
Please,
We'll write it now.
please.
Oblations.